And then I know we've talked about this primarily in terms of the PACT Act, where veterans with certain toxic exposures can get a presumption that their hypertension is service-connected. But for veterans with hypertension that they believe was caused by their military service or began during their military service, do they still have an avenue for getting service-connected disability and rating there?
Sure. The key thing is to look at the service medical records and see if there were unusual ratings there. I would keep in mind that most people, when they're in the service, are younger and more fit and have, therefore, relatively low blood pressure ratings comparatively than they're going to have in later life.
Oh, sure.
So it's important, if you want to establish that the high blood pressure goes back to service, to get the actual numbers in service. And, it's not uncommon to find elevated blood pressure readings during service, particularly for older vets that nobody paid much attention to.
Welcome to the Victory Over VA podcast, a podcast about empowering veterans to overcome denied disability claims. Each week, we deliver critical insights to help you understand the disability process, veterans' benefits, and how to take control of your legal rights. Now here's your host, Attorney Francis Jackson.
Welcome to Victory Over VA, your guide to unlocking your veterans' disability benefits. If you're a veteran applying for benefits, be sure to subscribe for the latest developments in VA disability. I'm Francis Jackson. This is Christian Terrison, and we're from Jackson and MacNichol, a law firm that specializes in getting justice for veterans on their VA disability benefits. So, welcome. What's this about? Well, this is about veterans and how they get their disability benefits. And so it's for veterans, but it's for anyone who's interested in veterans, spouses, relatives, friends, anyone in the community who wants to support their veterans and see that they get the disability benefits that they deserve. And today, we're going to talk about the issue of hypertension and veterans' benefits.
All right, and this came up because a lot of PACT Act cases have been getting service connection for hypertension, but then a 0% rating. So I guess to begin at the beginning, what is hypertension and how does the VA define it for disability?
Sure. Hypertension is just what we all think of as high blood pressure. Just means that your heart is working harder than it really ought to have to push the blood through your body. And there are various reasons why that happens, but it happens a lot to folks who served in Vietnam. So it's been shown to be a result, in many cases, of exposure to Agent Orange in Vietnam. And what the VA does is it rates hypertension based on the systolic and diastolic pressures that are found when you have your blood pressure checked. Typically, high blood pressure or any blood pressure rating is expressed in two numbers, like 160 over 80. So that first number is what's called the systolic. The second number is called the diastolic. Now, the way VA rates the severity of hypertension is by looking at primarily the diastolic, but secondarily the systolic. So if your diastolic pressure is 130 or higher, they will give you a 60% rating. If it's that high, they probably need to give you a hospital bed as well, but that's a different issue. That's very high. A diastolic pressure of between 120 and 129 gets a 40% rating from the VA. A 20% rating is applied if the diastolic pressure is between 110 and 119, or if the systolic pressure is 200 or higher. There's a 10% rating if there's a diastolic pressure predominantly at 100 or a systolic pressure predominantly at 160 or higher. And so keep in mind that word predominantly that I just used. What that means is, as we know, blood pressure varies day to day, time to time. So it's important if you are looking for a VA rating for high blood pressure to make sure you have lots of blood pressures taken over time so you can show what the predominant rating is.
Okay, and so when a veteran gets service connection for hypertension, it's the blood pressure numbers that would get them the 0% rating.
That's correct.
Okay, and so how critical is it to provide consistent blood pressure readings, when pursuing a higher rating?
It's absolutely critical.
Okay,
I mean, that is the evidence. There is
that's it.
Yeah, there is really no other evidence that you can provide.
Okay. Now, can veterans argue that their hypertension is causing functional limitations beyond, what's contemplated by those rating criteria?
Yes, they can. And medically, you can show that various other conditions can be caused by high blood pressure, even if it is not high enough to get you a rating above 0%. Elevated blood pressure does bad things over time. And so there are secondary conditions that can be generated. There are a variety of heart-related, cardiac-related conditions, and there are others. It's basically the question that you want to ask is if someone has high blood pressure and has had that since service, you want to look at whatever physical problems they're having and see medically which ones are potentially related to the high blood pressure.
Okay. And to succeed on a secondary service connection theory like that, saying I have this service connected high blood pressure that is caused or that is causing this other condition, how do you go about doing that? Is that
Well, first you have to establish that you're entitled to service connection for the high blood pressure. And it may be a little misleading of me to say first, you can actually apply for the high blood pressure service connection and the secondary condition at the same time. But first, in the sense that VA can't give you any kind of disability rating or compensation for the secondary condition until you establish entitlement to the high blood pressure in our scenario.
Gotcha. And so does the VA use CMP exams for hypertension issues?
They do.
Okay, so what steps can a veteran take to ensure that, during a CMP exam, their condition is fully and fairly evaluated?
Well, the primary thing you need to do is to bring a record of historical blood pressure readings. So, whenever your doctor has taken your blood pressure at routine appointments or any medical appointment, you should get a copy of those and be able to show those to the CMP examiner, because keep in mind that much of the time, the CMP examiner is only going to see you one time, and no matter what blood pressure reading they find, that's not going to show a pattern. So it's important to provide them with the historical pattern, especially of the particularly high readings. And this is not uncommon, if you have a situation where your blood pressure varies day to day or week to week, it's important to have a log of the higher ones. The lower ones are less important, if you will, in evaluating whether you meet the criteria, but certainly you want a record of all the high ones, and you want to be able to show the frequency with which you're hitting those higher levels.
Now, could a veteran be logging their blood pressure daily, like at home, and writing that down? Is that still
Absolutely.
acceptable as evidence?
The VA has to consider it. Let me say this in the best way I can. What you bring yourself to the VA as evidence may not be considered as credible or powerful evidence as reports from a third party. So if you bring to the VA examiner a whole list of high blood pressure readings, but your reading when he does the exam or she does the exam is quite low, they may be skeptical of the, of your handwritten list. Whereas if you bring a stack of printouts from your doctor saying on this date it was this, on this date it was this, on this date it was this, they will be less likely to be skeptical.
Yeah. And also the two combined together, say you go to the doctor only twice a year and you're getting high blood pressure ratings there, and then you have your home log that's showing comparable blood pressure issues.
Exactly.
Then
Consistency is the key.
even if you end up at the CMP getting a much lower blood pressure rating, which I've never been to a CMP exam, but from what I've heard, it's very unlikely. But even so, you never know what could happen with a CMP exam.
Exactly.
I've read enough of them to know to expect the unexpected. So in that situation, between having the third-party medical evidence and then your own home log, you would create that compelling story.
Exactly.
Okay.
Because as you were really outlining, it's the consistency that's the issue. Is there consistently high blood pressure, or predominantly, as the VA uses the term?
So yeah, the same way a few high numbers won't boost your rating, a few low numbers also shouldn't be, getting you a 0% rating.
Exactly.
So what options are available if a veteran believes that their 0% rating is inaccurate? They believe that they should be in a higher rating category.
Well, basically, they just have to collect the evidence. The only way the VA is going to give them a higher rating is if they're shown the higher readings. So, you can collect them at home, you can get the ones from your doctor, you can get it checked every time you go to the VA clinic, whatever combination of information is easiest for you to collect about the high blood pressure readings, but that's what you're going to have to show. Now, we have argued in several cases that the VA's current rating system is inconsistent with the development of medical science, and that these blood pressure readings that the VA relies on are unfairly high, and have asked judges to give a 10% rating based on more current medical literature. I don't think we've gotten any results in any of those cases yet, so I don't know whether that will work, but I think that's worth trying.
Yeah, well, because I know the baseline for years was 120/80, and that was recently revised down to 110/, I don't know what the systolic was, but
I think it might be 70, but don't hold me to that.
yeah, the medical expertise almost always moves faster than the VA.
Yes.
I'll say almost always only because, I'm a lawyer and I've been taught not to speak in absolutes, but I'd be very surprised if somebody could show me an instance where the VA outpaced the doctors.
Yep. I'd be equally surprised.
Indeed, indeed. So, are there common mistakes that you see veterans making when they're appealing a 0% rating for hypertension?
Well, the most common one is just that they don't take the time or make the effort to collect the ratings over time. And what that does is to let the VA say, well, this is just a fluke, you had a cold or whatever. There's some reason why your blood pressure was higher than usual at that time. This isn't the predominant rating.
And then I know we've talked about this primarily in terms of the PACT Act, where veterans with certain toxic exposures can get a presumption that their hypertension is service-connected. But for veterans with hypertension that they believe was caused by their military service or began during their military service, do they still have an avenue for getting service-connected disability and rating there?
Sure. The key thing is to look at the service medical records and see if there were unusual ratings there. I mean, keep in mind that most people, when they're in the service, are younger and more fit and have, therefore, relatively low blood pressure ratings comparatively than they're going to have in later life.
Oh, sure.
So it's important, if you want to establish that the high blood pressure goes back to service, to get the actual numbers in service. And, it's not uncommon to find elevated blood pressure readings during service, particularly for older vets that nobody paid much attention to. I mean, the reality is that 30, 40 years ago, high blood pressure readings, unless they were really consistent and really high, didn't get a lot of attention.
And I know that you've really emphasized the role of consistency when it comes to rating high blood pressure. For disability purposes, what about for a veteran who has different prescription medications, to lower blood pressure, or, somebody who's in the position where they're taking a medication for another condition and it actually elevates their blood pressure?
Well, different results depending on which way you're going.
Well, exactly.
Let me take the second one first. If the veteran is taking medication for a service-connected condition that is causing his blood pressure to be elevated or her blood pressure to be elevated, then that should be secondarily service-connected. That one's not too tough. The converse, the earlier one you asked, where the blood pressure is being controlled by medication. This is off the top. My recollection is that there is a recent case where the court said that you actually look at the blood pressure as it would be without the treatment.
Okay.
But I'd have to double check that to be absolutely certain.
Okay. So there is the possibility that even somebody whose hypertension is reduced by
treatment, yeah.
By treatment, they find themselves in a lower bracket than they were, or maybe even at 0% with treatment, that by showing it's the medication that's getting them there and they otherwise would be.
My recollection is that you can still establish the eligibility. I'd want to go back and read that case to make sure I'm remembering it correctly.
Okay. I was going to say, it's a rare thing where you don't just fire off the site. So
that one didn't stick. I'm sorry.
Well, you've still got a better track record than ChatGPT and Google. So, but we're almost out of time for today. What would your parting advice be to veterans who, have that 0% rating and think that, they got lowballed by the VA?
Well, I think there are only two avenues. The traditional one is to just trace the readings over time and, show that there are higher ones that VA either hasn't seen or has ignored. But as I mentioned earlier, medical science keeps kind of lowering the threshold for what they consider abnormally high blood pressure. And I am convinced, and we're continuing to pursue cases where the VA's standard is not met, but current medical science says this is elevated blood pressure, and making the argument that this should be done, this should be allowed based on current medical evidence, as a non-scheduler benefit.
That may be on the sophisticated side for folks who are, trying to do their own claims. Would you advise getting some outside help in those situations?
Yeah, I would say you're going to need an experienced advocate of some sort if you want to make that argument.
All right. Well, this has been another episode of Victory Over the VA. Thank you for tuning in. Please be sure to like and subscribe and join us again next week.
We'll hope to see you then.
Thanks for joining us this week on the Victory Over VA podcast. Make sure to visit our website, veteransbenefits.com/podcast, where you can subscribe to the show in iTunes, Spotify, or via RSS, so you'll never miss a show. While you're at it, if you found value in this show, we'd appreciate a rating on iTunes, or if you'd simply tell a friend about the show, that would help us out too. If you like this show, you might want to check out our free consultation to see how we can help you with your denied claim. Simply go to veteransbenefits.com and fill out the form. You fought for us. Now let us fight for you. And be sure to tune in next week for our next episode.